petitioner was not abducted. But we have many other cases where they have turned up dead or been produced later. So it is necessary that we say loudly those circumstances. And later we will share the affidavit with the press so that people, the court and the country knows that.
I will come to that.
Yeah, thank you.
I was at the point where, remember the Law Society filed an application to withdraw?
Yeah.
Before I allowed that application, I gave the second petition an opportunity
to file,
to get the benefit of legal advice as to what it means.
Yeah.
So now that he has an advocate, and it's now, for me, I think it is the point where we can dispose of that application.
Yeah.
Then now you take over the floor.
Thank you.
If that suits you.
I'm well directed. Yes.
So the previous firm of advocates are now discharged. The petitioner, second petition is now represented by the firm of Mola Kimosop Advocates, and shall henceforth be served with any proceedings relating to this matter. So what next? So who takes the floor? Senior counsel?
My Lord, we all were of the view that now that the second petitioner has been found that it was a habeas corpus application, this matter must necessarily come to a close. But we thought that time I did as an officer of the court that his side of the story be heard, because it's important that the court and the public do understand the genesis of this matter and why it took the course it did. He has, pursuant to the court's directions, filed an affidavit sworn on the 5th of August this year. In which he explains the circumstances that drove him into hiding incommunicado.
When is the affidavit sworn?
Sorry?
When is the affidavit sworn?
On the 5th, it's dated the
5th of August.
5th of August, sworn on the 5th of August.
That affidavit has been served?
It was, I believe so. It was served. Mr. Mola confirmed that it was served on all concerned.
Yes.
And he says that while out of his house on an errand, he learned that the police had broken into, or rather opened without his permission, his house, searched it, and had even changed the locks. So literally it was their house, not his house. And he details why he went into hiding without a phone. And we all know the role phones play in locating people. So he went without his phone, did not communicate with his family, his mother, or anybody, and did not know there was a case in court. When he surfaced due to his poor living conditions and got a phone to call his cousin, he learned of this case, and that's how he came out. And it does indicate, because of the previous incidents of police abductions, he feared. He says in paragraph 16 that he contemplated going back, but he feared likely abduction, torture, killing, or disappearance, and went into hiding to preserve his life. So without reading the whole affidavit, which is available for reference, those are the circumstances. And he annexes the affidavit of his mom, Margaret Rukwaro, it's Annexure 3, who also gives the circumstances in which he sought the help of the Law Society of Kenya when his son went missing. He was in a state of distress, mentally broken, psychologically, she was in a state of distress. And he also describes her son when she came from custody, from hiding, broken, physically distressed, and psychologically tortured by the circumstances. So in other words, in a nutshell, the mother of Ndiangui, when going to the Law Society, had reasonable apprehension, which any mother acted the way any mother or reasonable parent would. And also the second petitioner, by going into hiding, the way he relates in his affidavit, it was the way any reasonable person would answer. And I'm asking the court to take judicial notice that pending before these courts, there are various petitions of people who have disappeared, have not surfaced. People who have disappeared, turned up dead. I know of one case, E17 of 2024, 714 of 2024, in which, again, I was appearing alongside the Law Society, and in which the Law Society had named me as an interested party. And therefore, I was participating as a party. So I'm asking the court if the court so deems it proper to close this file, to close it with the understanding that the circumstances in which the second petitioner and his family reacted were circumstances in which any reasonable person would react just the way they reacted to preserve life. And therefore, to give them that indulgence. We want to thank the court because it gave protective orders. We have had cases of abuse of powers of arrest. The second petitioner has since presented himself to the DCI in company of one of his lawyers, Mr. Wahome, was questioned extensively. His properties, especially electronic gadgets, listed in this case as exhibits from and admitted to have been taken away by the officers who searched his house. We have had occasion to refer to them, are still in police custody. And police have not since then asked the court's permission to go through them, because they need the court's permission once they recover. So we are urging, as the court terminates this case, police be ordered to return those gadgets and to desist from harassing the petitioner, the second petitioner. Being a law-abiding citizen, anytime they require him, he will be available. And he has a fixed address, care of his lawyers. So I do hope my learned junior, Mr. Marrow, will be confirming, undertaking that there will be no harassment in the form of arrests over this very same matter for which he has recorded a statement.
I cannot confirm that.
Nimemaliza, you can respond fully. I've finished.
I see a document here. What is it?
Sorry, my lord.
I see a document NK1 in the affidavit. What is it?
NK1. Let Mr. Mola help me with that one. I believe it's a medical.
Yes.
It is a psychological evaluation report by Dr. Koko Muhammad, a psychological counselor.
Mr. Mola, is it the way it is attached here? Is it the one dated 4th of August?
The report is dated. Does it have a date? It has a stamp 5th of August.
Is at the end?
Oh, the date is 21st July 2025, the date it was done. But there is another one, NK2 from Kikuyu Hospital. Which is dated 4th of August. That's a second one.
So that's all?
That's all from us, only to alert the court that the annexure marked FM1, which is one of the last annexures, lists the properties in the custody of the police.
Yes.
And it's their own document.
Yes. Mr. Maro?
Your Lordship, on behalf of the 1st to the 6th respondents,
Yes.
I also wish to confirm that the order sought in the application, Your Lordship, dated 24th June 2025, in particular the order of habeas corpus, has since been spent. Your Lordship, we are lucky that the body produced himself, and the body has since sworn an affidavit that contradicts the content of the petition. With that as it may, Your Lordship, we will be requesting this court to close this particular file. Because the prayer that was sought, Your Lordship, has since been obeyed. However, Your Lordship, my learned senior, has made a number of submissions before this court, among them an order barring my clients from arresting the second petitioner. Your Lordship, we are opposed to those submissions.
Just a minute. Maybe I should have heard the Law Society before you.
They have been discharged.
No. They are discharged from appearing for second petitioner, not. The Law Society is a petitioner.
That's correct, Your Lordship. But since my flow of thoughts are geared towards a particular line, could you please allow me submit?
No, I'm drawing your attention to
Yes.
the fact that we may have jumped a step, or we'll come to them.
Yes. Your Lordship, my clients are opposed that particular prayer, stopping them from exercising their constitutional mandate under Article 157 and Section 55, the National Police Service Act. Your Lordship, I draw your attention to the Supreme Court authority. It's a 2018 authority, petition number 4. The case of Murithi versus Juma Jano Mohammed. In this case, Your Lordship, the court said an application for an habeas corpus cannot be contemporaneously had with any other claim for an alleged violation of fundamental rights, and to the extent that an order of habeas corpus has been issued and determined, the Honorable Court, and addressing this court, lacks jurisdiction to hear and determine any other issue. Any other issue, Your Lordship, is my emphasis point. Your Lordship, as you
In which
close,
decision?
the decision is Murithi.
Double I or single I?
Double I was suing as a representative of the
Murithi
estate
versus?
versus Jane Mohammed. Petition 441
No,
of
I'm still looking
2018.
for.
I shared this copy with the court. Petition 41 of
Court does
2018.
not keep files, Mr. Man. Let me check whether it is here.
Your Lordship, I can
No. Let me just check.
provide a copy.
No, let me check if it is here.
Yes, the submissions. It is in the submissions to my peer.
Petition
41 of 2018. It was delivered on 30th June 2023.
Did you give us a copy?
Yes.
Not the one we were looking for.
Yes, I still can supply a copy, Your Lordship.
Yes.
So, Your Lordship, in conclusion, if the second petitioner wants any other relief before this court, the second petitioner, through the advocates, can institute a fresh petition. But there should be no any other relief other than the order of habeas corpus in this particular matter. Your Lordship, I submit on behalf of my clients.
Thank you. Law Society.
Yes, my lord, I think the last time we were here, the instructions I had were to cease acting for the second petitioner.
Yes.
And you gave orders that he be given time to look for representation.
Yes.
And file an affidavit, which he has.
Yes.
So the instructions I have as at this morning is that we formally withdraw the petition and we marked the file as closed.
So you're Mr.
Yes, I'm Mr. Mutungi.
Mutungi.
Yes.
Okay.
Thank you, Lord.
Your Lordship, if I may, Mr. Mango for the Law Society. Your Lordship.
Are you different from Mutungi?
Yes, I'm Mr. Mango.
I know.
Yes, Your Lordship, just briefly, Your Lordship, in filing this petition, Your Lordship, the Law Society was enjoined by dint of Section 4B of the Law Society of Kenya Act, which gives the society the mandate and the duty to uphold the Constitution of Kenya and advance the rule of law and the administration of justice. Further, Your Lordship, Section 4D of the Law Society of Kenya Act also enjoins the society to protect and to assist the members of the public in Kenya in matters relating to or ancillary or incidental to the law. Your Lordship, the guiding principles of the society as espoused under Section 6 of the Law Society of Kenya Act.
Are you advancing anything different from what
No,
Mr.
Your
Mutungi
Lordship.
has told us? Because if you are reading to us the Act,
Yes.
we understand the Act.
Yes, we are just saying the
No one has
circumstances and
questioned-
why
no one has
we
questioned
enjoy.
that
Yes, Your
mandate.
Lordship. So we were protecting the rights as provided for under Article
Yes.
25 and 51 of the Constitution,
Yes.
and we shall continue to do the same before this honorable court.
Not in
For
this
the-
matter.
Not in this matter, and for the people.
Because Mr. Mutungi has asked that I close it.
Yes, Your
Are
Lordship.
you agreeing or disagreeing?
I am agreeing.
Your mandate is not questionable.
I am agreeing, Your Lordship. And I'm most obliged.
May I briefly respond on the authority?
Yes, Senior Counsel.
My Lord, the authority cited does not stop the court from issuing orders for release of properties. Maybe if we were asking for damages, he would be saying we now file a fresh suit, which we will in due course. But since the matters are before the court and the matters are admitted, we were just seeking for orders that they release what they are holding and that they do not use this occasion to harass. And those are not unusual orders. If they gave an undertaking for even 72 hours, we will have moved to file an application where they can bring their objections. And we are not in any way asking the court to stop police exercising the powers granted by the law. It's only preventing abuse. Why would you arrest a person who has already appeared in a station? It's just rampant abuse of police powers that we are seeking an undertaking that there will be no abuse of power in relation to our client who is already traumatized and the report is before the court. Otherwise, we are law abiding and we meet any charges brought by the prosecution if they so wish.
Lordship, if you may permit me, for a minute.
Can he reply to a reply?
For a minute, Your Lordship. This is because of what the Law Society has, the application that has been made by the Law Society to formally withdraw the petition dated 24th June 2025. They are the drafters of this petition. And there is a rule that parties are bound by their pleadings. If you look at paragraph 49, Your Lordship, of the petition dated 24th June 2025, that an application for withdrawal has been made, I then, Your Lordship, do not...
Which application?
The application that the Law Society, who is the drafter, has made to withdraw this particular petition as it is. So the petition collapses with the orders therein because it's been withdrawn. And the court cannot now proceed, Your Lordship, and grant any other order because now the petition has been withdrawn as it is. So the court cannot grant an order outside the petition that has been withdrawn. I believe, Your Lordship, that is the position. We have appeared before you, and that has been an order that this court has made time without numbers. It has been withdrawn. So the court cannot grant an order outside this particular petition. Your Lordship, that is all.
The application that has been made is informal, right? Or it is in writing?
Your Lordship, Ntunga rules allow...
No,
Yes.
it's informal.
With the truth.
It's the application made to withdraw has been made.
Oral.
Yes, my lord.
Yes, oral, Your Lordship. Yes, and the Ntunga rules permit such an application.
What is it again?
Yes.
There is just a minute. Senior counsel, there is a tradition that when a senior counsel speaks, that should really bring us to the end.
May I then say for him, he just wanted to agree with the court that the Mutunga rules, Rule 27, may not allow for an oral withdrawal.
You know, I know those rules. Those are the rules this court.
Yeah.
And I really, it's because I just don't want to say so many things. That rule is permissive. I still can refuse. And that's my understanding of the Mutunga rules, especially when you come here to withdraw petitions. Because these petitions, we look at them, we can. So let's not go there. You agree the matter is come to an end. I'm now trying to see how we. There are these documents that were taken. Mr. Maro. Yes.
Your Lordship, regarding what was taken by the DCI,
Yes.
and if you look at our affidavit, in particular the affidavit of Itegi, we did agree because there is an annexure. This is, Your Lordship, annexure. I'm referring you to the affidavit of Samuel Itegi. The affidavit, Your Lordship, was sworn on the 30th day of June 2025. confirming what they collected from the apartment. Your Lordship, the right to property is protected under this particular constitution. We are agreeable that these particular items are in custody of my client. And upon completion of investigation, the second petitioner has a right and a duty to go and collect his items. We have disclosed that we are in possession of these items. They run from item number 1 to item 6. That is not contested, Your Lordship.
What about 7?
Yes, Your Lordship, item 7, correct. Yes, I have not seen the second page of the annexure. So that is not in contention, Your Lordship.
Yes.
And this was not pleaded in the petition, but we disclosed that we collected these things, so they will be returned to him upon completion of investigation. I do not know the extent of the investigation as of now, but upon completion, he has a duty to go and collect his items.
When will he go? And who will ask him to go?
Your Lordship, if you remember the order that you made last time, he has been going to the DCI.
He has been going.
Yes.
He went only once.
Maybe he knows. Let him finish, Senior Counsel.
Yes, Your Lordship, he went, and I want to believe he can still go. It is a public office. And that's what I'm saying, he has a duty to go find out and ask for his property. This court is here also.
Did he record a statement?
Hello?
Did he record a statement?
I want to believe he did record a statement, Your Lordship.
He did.
Yes.
You've seen this report from the doctor? Mr. Man, you've seen some report from the doctor?
Your Lordship, I've seen this report, but I cannot confirm if it is from an authentic doctor. Because I'm not a medical
I
expert.
know, that's one question I would never ask you to confirm. You're not a doctor. That's all I ask is you have seen it.
Yes, I've seen.
We see the contents,
Yes.
nothing more.
Yes.
Yeah. Thank you.
The court allow me to comment on the property. It is more than a month, almost 2 months from the date they took the property without warrant. They are required, if they need the property for investigations, to come to court, even under the Cyber Crimes Act. If you take somebody's computers and gadgets, you go to court for permission to go and read the data. They have not done that. Passports, other documents, they have not come to court in 2 months to seek permission to retain documents and gadgets taken without warrant. These are the abuses we are asking the court to protect the petitioner from, and to also say that the writ of habeas corpus is about protecting individuals from deprivation of personal liberty. So although this case is coming to a close, abuse of power that would deprive one of liberty is something the court is seized of. Most obliged.
So I've had counsel for the parties. The first petitioner have sought to have this petition marked as withdrawn. The second petitioner's counsel has informed the court, and indeed the court has seen the affidavit sworn by the second petitioner on the circumstances under which the second petitioner disappeared in court. The affidavit is self-explanatory, and the court has taken into account the second petitioner's concerns that led to his disappearance. He went into hiding for fear of his life, and the steps taken by the second petitioner were not, in my view, extraordinary. The court has also seen the affidavit sworn by the second petitioner's mother and the circumstances that led to her instructing the first petitioner, the Law Society of Kenya, to take up this matter on behalf of the second petitioner. The first petitioner, that the Law Society of Kenya, acted based on the instructions given to it by the second petitioner's mother or his family. No offense can be attributed to the Law Society given the threats that have been going on recently. Fortunately, the second petitioner presented himself before this court alive, and it is important that this matter ends here. Regarding the items taken from the second petitioner's residence, the property belongs to the second petitioner in the absence of any claims of ownership by any other person. The police should be able to release or return that property to the petitioner once they are through with their investigations, if any. On whether this court should take further steps, should stop the police from taking further steps in arresting the second petitioner, I do not see the need to do so now. The second petitioner has been going to the police station and they have recorded statements. The police have therefore no reason or authority to frustrate or torture anyone, including the second petitioner, and should be reminded of the constitutional command that they have to act to the highest standards of human rights. And that, I think, is in the Constitution, Article 244, and also the Police Service Act. I do not want to recite it for them. Any threats against the second petitioner can be dealt with as and when they arise. This court need not act in anticipation. All in all, this petition is marked as withdrawn with no orders to courts. I wish you well. Thank you.
Most obliged, and we thank you for your patience.
So, Mr. Ndiangui, you can go to the police, they give you the documents if they are done with the investigations. Thank you.
Thank you, Judge.
Maro,
Yes.
I expect you to whisper to them to behave accordingly.
I hope I have their contacts.
To the highest standard.
Everything is relative. Depends on the person who is. Excuse me.